answer to charges of possession of offensive weapons alongside two other people. Njenga was arrested on the 20th of July as part of a government crackdown on Azimio-led protests. Let's listen in.
Article 157. Sub-Article 11 provides that the Director of Public Prosecutions shall not be under the control or direction of any person or authority. This means he is independent, and that brings the office of the Director of Public Prosecutions within the purview of Article 248(1). So we are an independent office. Being an independent office, under Article 253 of the same Constitution, the office enjoys perpetual succession. The office enjoys perpetual succession, and consequently, the departure of Mr. Nuruddin Aji as the Director of Public Prosecutions does not mean that the office ceases to exist or to function. Lastly, we urge the court to make a finding that all the allegations by learned counsel have been made from the bar. They are not substantiated. They are not on oath. And we cannot vouch for their correctness. These are just mere allegations from the bar. We urge the court to order that the proper forum for all those arguments is the High Court, not before you. We urge the court again to order that we take plea and we make the other applications. That will be all.
Why are you restricting me? You never restricted them. I'm already replying to points of law. I'm not going to repeat anything. What I'm saying, Your Honor, is that number one, my learned colleague, Mr. Ndubi, Mr. Njenga, learn to know my name because I'm always in the court. Yes. My learned colleague has raised serious constitutional and legal issues, which cannot just be washed under the carpet. This country is a democracy. They have said of independent offices under Article 248. Look at Article 249, A, B, and C. Those commissions and independent offices have to protect the sovereign power of the people of Kenya. Those commissions and independent offices have to promote the democratic values in the society of Kenya. Those commissions are not supposed to be subject to any other agency or authority. So what we are saying is this: contextualize these constitutional values and apply them to these three aspects. Number one, they were arrested on 19th. They are held incommunicado, no communication with the family or lawyers or anybody. Nobody knows where they were. They are now being sneaked to court 1 week later. Even when the High Court gave a habeas corpus orders, they never respected it. These people have a cash pay. The High Court gave them a cash pay of 100,000 shillings. They did not respect that. Your Honor, you took an oath. The oath you took was to protect, promote, and preserve the Constitution. And what we are urging you now is, Councillor has said that when you look at the office of the ODPP as currently constituted, there is a problem because there is an interpretative question whether the office, as currently constituted, can properly prefer judges against this. Because I know, even in anti-corruption cases, they cannot now file cases against anti-corruption cases because the office is not properly constituted. So we wanted to know how did they categorize that this one they can proceed and others they cannot proceed. So that is an issue for interpretation of the Constitution. Article 157 of the Constitution, which creates the office of the ODPP. That's what Council raised. Then, as read with Article 248 and 249, there is an issue which is conflicting. Now, the lower court has power, Your Honor. My learned colleague, Mr. Whitty, has misapprehended the Constitution. And with tremendous respect, the lower court has jurisdiction where an issue regarding the interpretation, application, and enforcement of the Constitution has arisen, it refers that matter to the High Court for proper adjudication. So what we are saying is this. Now that there is a serious constitutional issue that has arisen, you reject the charges under Section 89(5), as my learned colleague has said, of the CPC, so that you refer this matter to the High Court, you admit the subject persons to bond who are already on bond and the cash paid from the High Court, then this serious constitutional question be answered by the High Court. Then we can come back to you and tell you that, Your Honor, the High Court has directed that you can proceed or that matter is settled. That is one thing that I want the court to appreciate.
You're not even as counsel proceeds. We understand. This is an interjection. I'm allowed to do so.
I never interrupted you. Please.
Senior, I have to
he has no audience, Your Honor. If you say no.
Yes, please.
He has no audience when I'm speaking.
My interjection is we understood senior counsel to be responding to our arguments. He can only do so on a point of law and cannot raise a new issue. The issue of sending a reference to the High Court did not arise. How do we get a chance to do that?
Then he misunderstood the application by Ndubi. Ndubi said this is charge sheet.
And number two, Your Honor, Senior, I'm not done. With respect, Senior, you're my friend. Hatujakosana?
No, hatujakosana.
Number two is that you are being told about the issue of an order. You're not being told that any one of us here was served with any order. And the nature of that order. We haven't seen the order.
You have the
and
order.
That has been raised again in response.
There is an order from the High Court.
So we plead that the court takes charge of its proceedings and ensures that the rules of the game are respected.
Yeah. Your Honor, I've given you a copy of the order and I've given Mr. Mule a copy of the order. So the High Court admitted through habeas corpus number E-270 of 2023, gave the applicants, the subject cash bill of 100,000 shillings. I've given you a copy. Have you given a copy? Yes. So that one I wanted to raise it after. But now that in the course of arguments, it is important that you are aware. And we served it to their email address immediately. Yes. Yes. So these subjects are already admitted to pay 100,000 shillings. So what we are saying is this, Your Honor.
From the charge sheet, these are issues we raised when God have seen the made an application to oppose one of the issues to the list of problems. Let us wait.
We wait, yeah, that one. I've not mentioned that. And you can see I'm very organized and systematic. I've not mentioned anything which has not been mentioned by Mure or Wit, because I'm replying. So I know my boundaries. So what I'm saying is this, Your Honor. These constitutional aspirations are not just paper aspirations. They are meant to be enforced. It is the courts which enforce them. And that is the enduring value in our constitutionalism. That's why people respect us, that Kenya is governed by the rule of law. But if police are allowed to just come and arrest you and they brand you with anything, even when you have never smoked in your life, they will say you were found with Msokoto. Then that's a lie. And it must be said, called a lie. And yet we carry Bibles to the church on Saturday and Sunday. So let me concentrate on my reply. So what I'm saying, Your Lordship, is this: if you look at section 134 of the CPC, it is very clear. That I understood Mr. Ndobi to be saying that when you bring a church before a trial magistrate, the statement of the church and the material particulars must be so clear so that the suspect is able to appreciate what charges are being laid against him. Then he is able to understand and prepare. If it's a matter that can take him to the gallows, he appreciates that fact from day one. That is what I understood my learned colleague raised. So, and looking at the charge sheet, on the face of it, there is a problem. The material particulars and the statement of the offences is not even consistent. It does not comply with the section, Article 50, Clause 2B of the Constitution, which is very clear. 2B, 2B is very clear. The statement of the offense and the material particulars must be very specific so that it's understood. That is what the council was saying, that this charge sheet does not meet that legal threshold. So what are we saying? As at the moment, there is no proper law of charge sheet disclosing an offense before you to warrant you to take the charge. Your duty now under Article 1, Clause 3, I think C of the Constitution, as read with Article 159A, is you have powers from the people of Kenya. You declare that these subjects go home on reasonable cash bail. They will attend court or CID, whatever they want, wherever they want them to report. But they will report as and when needed until proper charges are brought. Not these concocted charges, Your Honor. This is a democracy. So we are beseeching you, if you look at our article, Article 10, look at the preamble, look at Article 20, Clause 1, and I want you to read them. When you read them, it says, state officers, including judicial officers, are obligated to preserve, promote, fulfill, and protect the suspects. Yes. So, Your Honor, you are not writing, but I hope you read. Yes, I can observe. I'm a good student of jurisprudence. Yes. Yes. So, because if you are not writing, how will you remember? After we finish it, you will have nothing in the record. Yes. So what I'm saying is this. We have come before you. The Lord of Abraham, Isaac, and Jacob has given you this position to be here now, today, so that the history is on your side. You can either build yourself so that you are a better and excellent judicial officer, or you can also be among the statistics that you once served in the judiciary and you never killed anyone. That is a fact.
The court should take.
Yes.
I'm not recording that.
Yes.
Yes.
I don't want to take a lot of time. How do we determine these issues of risk? That's now the right of and I think
yes. In fact, what we are saying, Your Honor, since already these people have been admitted to bail,
it's okay.
You cannot entertain any application that they are opposing bail.
No, we have not even gotten to that.
Yes. So I'm urging you that you make a finding that these charges violate Section 89(5) of the CPC, and you reject them, so that you will give further orders. Yes.
Yet there is an issue which was raised when they were arguing, and I am seeking leave of the court to answer that one.
Perhaps, Your Honor,
I've sought leave.
It's okay. It's okay. Before you say,
don't allow anybody to speak. Retire and make your judgment. You are ruling.
no, the only thing I was requesting, I think I heard you mention that there is an application for an affidavit of opposing bail. They have an affidavit of opposing bail, which I have read.
What I'm saying is that the charge sheet is here.
Yes.
And when I've looked at it, I came here.
Yes.
So I saw this application. So I'm saying, let us go in and see. Let's get there first.
Unfortunately, we haven't been served with the
We have
application.
served.
That's the point.
We served.
No,
we
we serve.
Or they served.
I can
Look,
hear
we
you.
served this on
No, I've said.
I apologize. I apologize.
So, Your Honor, may I address you on one
What
issue?
did you not address?
They have talked about cases of anti-corruption not being brought to the ODPP. I will tell you why. Because it's a legal point, Your Honor.
It's okay. That one, I did not even record this.
He did not.
Thank you, Your Honor. We are guided. We are guided, Your Honor.
So, I think we let us get to that point. Okay, what I've said, the accused are charged with various offenses. I've looked at the charge sheet. The defense has raised some issues which need